Welcome back to the Liberty Block podcast. I have another short video today on a Supreme Court case related to First Amendment law. And as I go through my book, I'm finishing up another one of the chapters of my book. This one concerns defamation and a lot of similar free speech, free press areas. This case is from 1971. It's a U.S. Supreme Court case called Rosenbloom versus Metromedia. It's interesting and important, and it has involvements of police, searches and seizures, defamation, press freedom, and free speech. And it's very interesting because I kind of have conflicting views about the case for a few reasons, and I have conflicting views about the outcome and the effect that this case and the decision of the Supreme Court has on the First Amendment and other freedoms. So this was 1971, so this is like 50 years ago, where obscenities were illegal. Obscene material, like they talk about girly magazines. I guess maybe like Playboy, maybe there were nude or somewhat nude women in these magazines, and that was illegal. Now, interestingly, side note, as I cover in chapter 3 of the book all about obscenities in this book, those are still illegal. I think like every state has laws about it, and any obscenity, like saying the word fuck, or like having even semi-nude pictures of even adults, those are all technically illegal to distribute or even possess. And I discuss in chapter 3 the pretty famous case from a few years ago of a guy who was pulled over in Florida because he had a bumper sticker that said "I eat ass," and the cop arrested him, and everyone said the cop was violating the First Amendment, violating the law. But I looked into it, and Florida law did clearly say that it's a crime to possess, and especially to display, an obscenity, and that was probably objectively obscene. So anyway, this is a long time ago when obscene magazines were illegal, but in parentheses, they're still illegal, technically. Other courts obviously would be a lot less reluctant, a lot less against ruling those laws unconstitutional as applied to those people or on its face. So anyway, a person named George Rosenbloom, apparently in the Philadelphia area, I believe, was distributing these nudist magazines. This was a violation of, I believe, a city law on obscenities, but I think all states have laws banning obscenities. So I discussed that in a different chapter, but this is a case more about defamation. That's why it's not in the obscenity chapter. It's a really defamation case. Anyway, this person was arrested when the cops found out about this, and pretty much they arrested those distributing them at newsstands because I guess Rosenbloom distributed these nudist magazines to various newsstands in the area. Again, this is 1960s, and they seized and arrested some of the news distributors. They call them newsboys here. And then when they were seizing from these magazines, the cops were seizing some of the magazines from one of the stands, the actual guy, George Rosenbloom, who's the plaintiff in this case, he came by to do a regular delivery of his magazines to one of these newsstands. The cops saw him delivering them and immediately arrested him and charged him with, delivering obscenity, distributing obscenity, whatever. So he was arrested, not yet convicted. While he was arrested and charged with these obscenity crimes, the police officer, or Captain, let me get to his name here, Captain Ferguson, I believe it was, called the news stations, and I kind of think this is where I'm going to get into opinion here. I think it's not necessarily appropriate for cops to call news stations, and he made phone calls to some radio stations, some other media. They call it the news wire. It's an old term. I do not really know what it means, but he called a few media organizations to tell them of the arrest. I understand the public concern. If you're arresting a suspect in a serial murder case, you want people to know that there's been an arrest so they can maybe be less worried or maybe be on the lookout for certain things. But for a case like obscenity, I don't think it's such a matter of public concern that you tell the news stations when you make an arrest, because now the guy is presumed guilty and not presumed innocent. I wrote a whole book on presumption of guilt back there. So I'm not necessarily in favor of this, but whatever. I guess it was standard practice. That's not really an issue in this case. Captain Ferguson called the news station. One of them was operated by WIP, owned by Metromedia, I believe. They call it the WIP radio station. So that was owned by Metromedia, and that's the defendant in this lawsuit. So, let me just go through the whole case here. So that radio station broadcasted right away, and they have like every 30 minutes they broadcast the news, and I guess it's pretty local. They broadcasted a segment called City Cracks Down on Smut Merchants. Smut, S-M-U-T. Kind of an older term, but it means dirty, disgusting, obscene, whatever, perverts. And they said the quote in the actual report was, "The Special Investigations Squad raided the home of George Rosenbloom in the 1800 block of Vesta Street this afternoon. Police confiscated 1,000 allegedly obscene books at Rosenbloom's home and arrested him on charges of possession of obscene literature. The Special Investigation Squad also raided a barn in the 2000 block of Welsh Road near Burstleton Avenue and confiscated 3,000 obscene books. Captain Ferguson says he believes they have hit the supply of a main distributor of obscene material in Philadelphia." End quote. So, I don't think that report is that terrible. They said allegedly once, they said charges, and they said, I think they said reportedly. But in one of the sentences, they said confiscated 3,000 obscene books. They did not say allegedly or reportedly in that instance. So during one sentence, they did say the books were obscene. Now, interestingly, according to the record, they did not mention the name of Rosenbloom. But they did mention the address, essentially. They mentioned the block by saying the 2000 block of Welsh Road and the 1800 block of Vesta Street. Do people in the town know that refers to this one establishment that was Rosenbloom? I don't know. But saying that this seller of nudist magazines on this exact block probably is identifiable enough to one person that I could say that could support that element of defamation. Okay, but they didn't say Rosenbloom is a smut merchant, so that's interesting. They ran that 2 times. The third time they ran that segment, because they run it every half hour or a few times a day. By the third time, so that evening, they corrected the third sentence to say reportedly obscene, instead of just 3,000 obscene books were confiscated. So they fixed it. Also, interestingly in the case, they were reporting on Rosenbloom's lawsuit against police for seizing the books. So he had sued the police at the same time. So there's already a lawsuit going on by the time this happened. So in reporting the lawsuit against the public officials declaring that his books were not actually obscene, the reporters on the radio station, like the radio hosts, I don't think they were really opinion hosts, they were giving the news, but later on in the lawsuit in the courts, the director of the station seems to say that the actual hosts have some editorial discretion, or they were working under 30-minute deadlines, and it was hot news, and they couldn't really confirm as well as other news persons could confirm stories. So, and the court actually agreed that they gave them some leeway, some grace for not confirming stories before reporting it without being liable for defamation. So anyway, as these radio hosts were reporting on the lawsuit, they referred to them as smut distributors and girly book peddlers, and said, let me find the quote here. So the exact quote that the radio station broadcasted was that the judge will hear arguments today from 2 publishers and a distributor, all seeking an injunction against Philadelphia Police Commissioner Howard Leary, District Attorney James Crumlish, a local television station, in a newspaper, ordering them to lay off the smut literature racket. So it was that language, the smut literature racket, that was defamatory. So it was those 2 things, calling the lawsuit in that way and reporting on the arrest and confiscation of the allegedly obscene magazines that caused Rosenbloom to sue. So, he sues in federal court claiming diversity jurisdiction. I read it and I don't see where it says why, but in short, diversity jurisdiction is one of the ways a person can get to federal court, because this is a Pennsylvania case. They actually utilize the Pennsylvania libel statute, and I guess one of the parties operated in another state or in various states, in more than one. My best guess would be Metromedia was a large radio station operating in more than one state, and Rosenbloom and his lawyer utilized that fact to bring the case in federal court because they thought it would be more favorable. So anyway, they sue in the Eastern District of Pennsylvania, and the judge instructs the jury to... The judge told the jury, as per Pennsylvania law, that 4 findings were necessary for them in order to return a verdict in favor of Rosenbloom. 1, that one or more broadcasts were defamatory. 2, that a reasonable listener would conclude that the defamatory statement referred to Rosenbloom. 3, that the radio station forfeited its privilege to report official proceedings fairly and accurately, either because it intended to injure the plaintiff personally or because it exercised the privilege unreasonably without reasonable care. And 4, that the reporting was false. So the jury was instructed that Rosenbloom had the burden of proof on the first 3, but on the 4th, that the reporting was false. The defendant, the radio station, Metromedia, would have the burden of proof. He also instructed that, as a matter of law, Rosenbloom was not entitled to actual damages for claimed loss of business, not because it wouldn't ordinarily be, but because there has been evidence that the same subject matter was the subject of other broadcasts over other television and radio stations and of other newspaper reports. So if there was lost business, they couldn't prove that it was linked to the Metromedia broadcast. Okay. On the question of punitive damages, which is just damages for deterrent purposes, the judge gave the following instruction. If you find the publication arose from a bad motive or malice toward the plaintiff, or if you find that it was published with reckless indifference to the truth, if you find that it was not true, you would be entitled to award punitive damages, and punitive damages are awarded as a deterrent from future conduct of the same sort. The jury returned with a verdict for Rosenbloom and awarded $25,000 in general damages and $725,000 in punitive damages. The district court judge reduced that from $725,000 to $250,000. Now, Metromedia appealed from the federal district court to the Third Circuit Court of Appeals, the federal court. They reversed, and it's a little bit complicated and involves a lot of factors, but the biggest reason they seemingly reversed that decision by the jury was that the case, the reports, concerned matters of public interest, in that they involved hot news prepared under deadline pressure. The Court of Appeals concluded that the fact that the plaintiff was not a public figure cannot be accorded decisive importance if the recognized important guarantees of the First Amendment are to be adequately implemented. For that reason, the Third Circuit held that the New York Times versus Sullivan standard of actual malice applied, directed that the judgment be entered for Metromedia, holding that as a matter of law, petitioner Rosenbloom's evidence did not meet that standard. So the Third Circuit, in a really big reversal, they reversed the jury verdict and essentially said, because the issue was of confiscation of obscene magazines, allegedly obscene magazines, because he was actually acquitted, almost missed that part. Rosenbloom was acquitted by a jury, I believe, while this was happening. So the actual charges he faced for the obscenity, he was acquitted, and so essentially a court ruled that the magazines were not obscene. Okay, so anyway, he's not a public figure. No one argues that Rosenbloom was a public figure, because if you remember from New York Times versus Sullivan, I believe 1964, so 7 years prior to this, Supreme Court case decision, but probably only like the same time or a few years before the actual case started, which I think was 1967 or 68. The Supreme Court ruled in New York Times versus Sullivan that for a public figure to sue, the person suing, the plaintiff, must demonstrate not just regular elements of defamation, that it was wrong, it was false, and it hurt the person's reputation, caused some damages maybe. They also must prove that it was made with what's called actual malice, but it's not actual malice. It's just a higher standard, not just like they misspoke or they said something that was not true. It was reckless disregard for the veracity of that statement. So just a more reckless standard of real indifference to the truth of the matter. So it's a higher standard, and that's given to public figures, which theoretically makes sense. Common sense would say if I say Trump is a dumb monkey or Biden has dementia, Biden and Trump should not be able to sue me for that because they're public figures and the reason why the court gave this elevated standard, I believe, is because first it's important that citizens have the right to speak freely about public figures. It's a public important interest, a matter of public interest kind of thing. Biden and Trump have a bigger budget, bigger loudspeaker, bigger megaphone to counter those attacks by me. In this case, they're public officials, they're government officials, so they're even more accountable. They should be even more vulnerable to public scrutiny and criticism. They can obviously fight back in the media. They have the money, they have lawyers, they have ways of getting to the media to make statements counter my statements. So that's why they have an elevated standard, which I think does make sense. So, but Rosenbloom was not a public figure. He was just some dude selling smutty magazines. I mean, some dude selling, possibly nude magazines allegedly. But this is where the court kind of, I think, goes a little beyond what they should be doing, which is adjudicating cases, and they kind of legislate, saying we're going to massively expand the New York Times versus Sullivan theory, the higher standard of actual malice, to also include matters of public interest. And I guess what they're saying is obscene magazines, or the arrest and the confiscation regarding obscene magazines, even though he was acquitted, that's a matter of public interest, and therefore, in order to get damages, in order to win a defamation lawsuit, the person complaining about a matter of public interest that was reported by media must prove this elevated standard of actual malice. He must prove that they were really reckless about the truth and didn't do due diligence, which is obviously up for interpretation. It's kind of arbitrary, but he must prove that higher standard. So the Third Circuit said that, and the Supreme Court agrees with the Third Circuit. So, on one hand, this, I think it's good because it maintains press freedom, this case, the case of Rosenbloom v. Metromedia. It supports press freedom. The press can publish stories about an arrest, which was factual, it's true, he was arrested. They made a mistake, and I think it wasn't even a big mistake. I've seen bigger issues than this. They made a mistake by, in one of the sentences of 3 sentences, they didn't use the word allegedly preceding the word obscene, but they used it in the other sentences. So they corrected it pretty much immediately. So it wasn't that big of a mistake, but also, again, I wasn't there, so I don't know how hard the reporters did actually try to confirm, to corroborate the story with other sources. I'm going to link to the whole case here, and you can read in the record. The director says that the reporters generally don't have a lot of time, but they do usually try to confirm from other sources, and they use good sources, and they try to confirm stories before reporting on them. But in this case, it wasn't like an egregious thing of them saying this guy Rosenbloom is a total scumbag. I mean, they clearly were negative about him as far as their opinion, but that's their right. They called him a smut peddler or something. But they didn't say he was convicted and it's confirmed that he was selling horrible nudie magazines and he's a horrible person who's breaking the law. They said he was arrested. This is what Captain Ferguson told us. He was arrested. This material was seized, which is true. So I think that it's good that news has protection for that. On the other hand, people who are really just private citizens, not public figures, who don't have the means that Trump and Biden do, if they want to sue for defamation, if it's a matter of public interest, which I still have pretty much no clue what it means, because anything could be a matter of public interest. If it's an interesting case, anything could be that, if the court says it is, then they have to overcome a much higher burden to win a defamation case. So I guess what I'm saying is this case in 1971, when was this case? Yeah, 1971, the Supreme Court established, or Third Circuit, and then the Supreme Court affirmed that even for a private citizen to win a defamation lawsuit, they have to overcome a way higher burden. So that could be good, could be bad, it depends. But that's why I think it's an important case. And as always, I don't want to be at the wheel. I hate redundancy. So I only make videos where I don't find any. There was one video online. It was like 2 minutes. Very, very simple video. There was nothing else besides that one video I found about this case. Rosenbloom versus Metromedia. So I wanted to make a video, and it forces me to learn more about the case, which is good. So let me just see if there's anything else of note in this case. It's not a short one. It's kind of on the longer side as far as the whole Supreme Court decision. It was 5-3, I believe. Let me just double check. I'm going to link to Justia and Oyez, which has a really simple interface for reading Supreme Court cases. Yeah, a 5-3 decision. One of them didn't participate. And yeah, that's pretty much the outcome of the case. It just elevated the standard for suing for defamation for a matter of public concern. Now, it involves so many issues. Just the issue of obscenity I do cover in chapter 3 of my book, and I have a whole lot about that. Again, a lot of Supreme Court cases about that one. So every chapter of my book is going to cover a whole massive area of First Amendment related law, and the average chapter also addresses and kind of analyzes and discusses like between 10 and 25 Supreme Court cases for a total of like 1,500 to 2,000 throughout the whole book. So kind of every Supreme Court case that touches on First Amendment rights, I do address in the book. I read them, I analyzed them, so that's why the book is taking years to write. So it's going to be the biggest book on the First Amendment. So hopefully this video can provide some value to you and also make you somewhat excited for the book coming out maybe this summer or fall. So stay tuned for that. Thank you very much for listening. As always, check out libertyblock.com and aluaxelman.com. Follow me at aluaxelman on X, at libertyblock on X. Thank you very much. I'd love to hear your thoughts in the comments, and let me know if there's a First Amendment related case that you would like me to discuss that's not already online on YouTube or some other video platform, and I'll be happy to do it. Thank you very much.